Good morning.
Morning, Your Honor.
How about we'll do Mr. Lee first.
Yep, just step right over to the desk.
How are you, Mr. Sarge?
Very good, Your Honor. Thank you. How about yourself this morning?
I'm good, thank you. All right, we're on the record in docket 23-00288. That is people of the state of Michigan versus Doyle G. Lee. Sir, you are Doyle G. Lee?
Yes.
All right, and you can hear me all right, Mr. Lee?
Yes.
Counsel, your appearance for the record?
I'm sorry, say that again.
Counsel's appearance for the record from the Public Defender's Office, Mr. Lee.
Good morning, Your Honor. Jacob Sarge IV, Assistant Public Defender, appearing on behalf of Mr. Lee for this appearance and this appearance only.
All right, so this is the time for the arraignment, Mr. Lee. I'm going to read you the charges that have been alleged against you and then read you some rights to coincide with those charges. All right, sir?
Okay.
All right, it is alleged that on or about December 7, 2022, at the offense location of 2417 East Jolly Road, Apartment 16, City of Lansing, Ingham County, yourself, Doyle G. Lee, did in count one make an assault and or assault and battery upon Rhonda Phillips, an individual with whom he had a dating relationship. That's contrary to the law of the state of Michigan. That's 750.81 parents 2. Restitution may be ordered in this case if there was loss of physical injury or property to another individual pursuant to 780.811A, 93-day misdemeanor and or $500. A consecutive sentence may be imposed if this assault happened in a place of confinement. So this is a 93-day misdemeanor and or $500. Do you understand the nature of the charges that have been alleged against you, sir?
Honestly, no, this is my first time going through this.
All right. So do you understand that you've been charged with a domestic assault?
Yes.
And you understand that that domestic assault relates to Rhonda Phillips, who is a person who had a dating relationship with you. Do you understand that?
We never dated, but yes, I do know who you're talking about.
All right. I'm only indicating it's an allegation and that the misdemeanor, and it's a misdemeanor punishable by 93 days and or $500. Do you understand that, sir?
Yes.
Okay. You have certain rights in this misdemeanor case, and I'll indicate those rights for the record. You have the right to a trial of any kind, bench or jury. You have the right to be tried by jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question any witnesses against you. You are represented by Public Defender Jacob Sarge for purposes of this arraignment. Do you plan to seek further representation from the Public Defender's Office in regards to this case?
Your Honor, unfortunately, Mr. Lee makes too much money to qualify for a public defender. And just to clarify for the record, Mr. Lee, will you please spell the correct spelling of your first name?
Doyse.
Doyse Lee. All right, thank you. I may have just been pronouncing that wrong. I have Doyse, Doyse Jean Lee. Yep. All right, and thank you, Mr. Sarge. And you plan to retain an attorney in regard to this case?
That would be our suggestion to Mr. Lee. Financially, he makes too much money to qualify for a public defender. We would certainly encourage him to get counsel for this and retain an attorney.
All right, thank you. So in regards to this future, I'm going to go ahead that you don't have an attorney from the Public Defender's Office, and the advice was to seek counsel in this case. All right, Mr. Lee?
Okay.
All right. You have the right to have the court-ordered witnesses in your defense appear at trial. You have the right to remain silent during the trial. You have the right not to have that silence used against you in trial. And you have the right to testify at trial if you choose to testify. Do you understand your misdemeanor trial rights in this matter, Mr. Lee?
Yes.
All right. Your next date that I see will be a pretrial conference in front of myself. That would be in front of Judge Flores on March 14th, 2023 at 9:30.
Okay.
do you have a current address for the court file where you can receive any type of information from the court? It would have to be different than the 2417 East Jolly Road, apartment 16 address. Your apartment 17, because there'll be a no contact order. So do you have an address that for the court file in regards to getting any type of notice?
She doesn't stay there anymore.
All right. I don't know where she stays. I just know that there's going to be a no contact order
That's
with
fine,
the
but
victim in the case. And so if you're confident that you can stay at that address without getting a violation of a no contact order, but if you're not, you should give me an address that you're confident to stay at, because we'll just end up in the same cycle again. You'll just end up with a bench warrant, no contact order, and you'll be right in front, and that's just gonna be another problem. Do you have an address for the court file that you can stay at to ensure that you will not be within the no contact zone of the victim?
I am completely positive that I will have no contact with her at 2417 apartment 17.
All right, no contact means you can't be within. Well, no, we changed that. We're supposed to be. No, it's that was one of the things we came. So it's 1,500 feet at this time that the judges have decided is supposed to be the consistent amount. So you're confident that you'll be out of 1,500 feet of range of her?
Yes.
All right. I'm gonna indicate, all right, that she's not living there. You're gonna be out 1,500 feet. If you're in violation of this order, the no contact order is on you. All right. You're to have no contact with her. But if you're confident that she's living elsewhere, and Mr. Sartz, that's your understanding?
Your Honor, my apologies, but I have to defer to Mr. Lee about these circumstances. I would have no other independent sources of information at this point.
Right. I understand that this is coming from the defendant. I'm gonna indicate the current address is Lansing 48910. And then we'll address the no contact part of the equation when we get there. Do you have a phone number for the court file, Mr. Lee?
Yes.
And what is that?
989 293 6483.
6483. 989-293-6843.
No, 6483. Yep.
6483. Okay, thank you. Are you on probation or parole, sir?
No.
Are you employed?
Yes.
And where are you employed?
2 places, Morgan Properties and Clean Team.
What was the second one again?
Clean Team.
Clean Team. Yeah, I'm going to automatically order a not guilty plea for purposes of this arraignment. Counsel, would you like to address bond?
Thank you, Your Honor. Mr. Lee, to his credit, is a very industrious and hardworking person who works 2 jobs. That's a big reason why financially he doesn't qualify for a public defender's office. He has connections to the community. He's lived here since 2016. To the best of Mr. Lee's knowledge, he doesn't have anything in terms of his adult history and nothing recent in terms of any convictions along those lines. Obviously, Your Honor would have access to lien. I have to defer to Mr. Lee's representations, but based on his representations to me, his exposure to the criminal justice system should be very minimal at this point. As he's made it very clear, he's going to understand the court's orders and stay away from Miss Phillips as this case proceeds. To the best of my knowledge, Your Honor, he has no issues with any flight or anything along those lines. And because of the strong connections to the community, given the type of charge here, given that it's only an allegation of the 93-day version, well, it is, an allegation of assaultive behavior, it's still the level here is a 93-day, and given his very clear work schedule, which is going to keep him very busy, I would respectfully request a personal recognizance bond on his behalf. Thank you.
Thank you. If the defendant's able to make bond, I'm going to set the following bond conditions. There is to be no use of alcohol or drugs, no assaultive behavior, no out-of-state travel, no contact with victim. The victim in this case is Rhonda Phillips. I'm going to order a GPS with exclusion zone. Which will be different than the victim notice. Just for purposes that we don't often know where the victim is, so we can't put a victim. I've been told that we can't use the victim's address, so we use an exclusion zone instead. They requested that we did do that. No possession of a firearm. I have a limited criminal history. That is correct, Mr. Sartz. In this regard, there seems to be older files. There does seem to be no data received on some assaultive behavior, but there is a 2012 misdemeanor possession of marijuana that the courts are not going to put a lot of not a weight on. I'm going to set bond in the matter because it is an assaultive crime. I'm going to set bond at 2,000, 10%.
Your Honor, may I just address a concern I have as it relates to the tether at this point?
Sure.
Thank you, Your Honor. Respectfully, there might be some significant complications as it relates to tether if the complaining witness has moved out of that address, which apparently was listed in the file. That could be quite problematic if the only address that we had for the complaining witness was the exact address that Mr. Lee intends to return back from. And we're relying here on Mr. Lee's representations that the complaining witness has since moved out. I would respectfully request that perhaps the court consider holding off on a tether requirement for right now, because in effect, what would happen is unless we have a verified release address, Mr. Lee would have to sit in jail until they get in contact with the complaining witness, get an updated address, and only then would he potentially be released. And as a result, Mr. Lee could be stuck, even if he posts his bond, for several days or longer until JSG sorts out where Ms. Phillips is actually living at. So,
Right.
given
Yeah, go ahead, Mr. Sartz.
My apologies, Your Honor. That would just be a concern I would have with potentially imposing a tether requirement at this time. It occasionally will take several days or longer for JSG to verify an address for a complaining witness, and as a result, the person can be stuck until they're able to do.
That was my fear as he gave us the address that he did, that we were going to have an exclusion zone problem in regards to this GPS. Because right now, the last address of the victim is the last address of the defendant, and he has the no contact order, and he has the GPS tether, and we're relying on information that is brought from him to tell us that this isn't a problem. And I'm uncertain if it's a problem or not right now. So that's why I was thinking if he has any place else to stay and he can get his stuff until this is worked out, that'd probably be the safest avenue, rather than going back to that 2417 East Jolly address and having that as the last address of the victim, and then you're in violation of the no contact order. That's my fear. Yes,
Mr. Lee, Sorry, Your Honor. Mr. Lee,
Go
you
ahead.
have a friend's house or maybe a family member that you could stay at least temporarily, that we could list this as an address until we get this issue cleared up?
I have a brother, but I am so positive. I live where I work at, honestly. And my office manager can confirm that she has a different address.
Just
But
as long, what you're telling me, and this is what I want to avoid, is that it can be confirmed, but you may have to stay in jail till it's confirmed. And that's what Mr. Sarts is trying to get around, is trying to avoid, is that you sit in jail waiting for confirmation when you actually have made bond, and a new address for notice may take care of that situation.
Okay, I have an address. I just don't know it by memory right now.
All right. I'm gonna put on the current address to be determined, and then you can provide that. But that will at least, I think that will allow you to make bond and not be warranted on the exclusion zone until it's confirmed. And I just didn't want the same address to be a part of the exclusion zone. If we can confirm that the victim's not there anymore, that's my fear, Mr. Sarts. Is that your fear also?
Yes, Your Honor, that JSG is going to be unable to release them until they get a verified address, and that the only address they would have is the complaining witness's address. And as a result, Mr. Lee would be stuck for several days or longer.
Right. So
if she doesn't cooperate, if she doesn't return their calls, he could be stuck in jail for a week, even though he's posted his bond.
Right. So I'm going to say I'm going to indicate for the record that the current address is to be determined by defendant. It's his brother's address in Lansing. Is that a Lansing address for your brother?
Yes.
Okay. Brother's address in Lansing, and once you get that and provide that information to the contact, that should place you out of the exclusion zone until we can figure out that she's not there, confirm it. Because in the interim, my preference would be that you have the opportunity to make bond and get out, and not that you're stuck because we're trying to figure out if the confirmation of the address is correct. All right, sir?
Okay.
All right. So your next date would be so I'm going to indicate for the record that the current address is to be determined by defendant's brother's address in Lansing. I have the number. As soon as you get that address, let everybody know that. That'll be the current address that you get your notice of, and that'll provide some interim time period to confirm that the victim is not at the listed address for exclusion zone purposes. All right, sir?
Okay.
All right. Your next pretrial conference is on March 14th at 9:30. Anything else for the record, Mr. Sarts, in docket 23-00288?
Nothing further, Your Honor. Thank you, and thank you for your understanding given the circumstances with this potential tether issue.
Absolutely. All right, Mr. Lee, we will see you on your pretrial date. All right.
Okay.
Okay, you're all set. Thank you for your appearance today.
Thank you.
And we'll do a Mr. King. I might have to sign something there. Then, all right, so we're on the record in docket 22-02841. That is the people of the state of Michigan versus Merle King. Will the parties please introduce you, sir? You are Merle King, spelled Murleking.
Yes, sir.
All right, thank you. Mr. Sarts, your appearance for the record.
Good morning, Your Honor. Jacob Sarts, the Fourth Assistant Public Defender, here on behalf of Mr. King for these proceedings only. Aaron Schroeder, Assistant Public Defender, represents Mr. King on the underlying case here, Your Honor.
All right, thank you. This is the time set for arraignment to tell you the nature of the bench warrant that was placed out for you concerning this violation. This was a PA 53 violation on a no contact order out of Judge Buchanan indicated on February 20th, 2023. I do have that. I took a look at that order, and that order was that you were to have no contact with a Nina Mata. On February 20th, 2023, Judge Buchanan ordered you're to have no contact with Nina Mata and set bond on this DV in regard to that. In regard to that, you were picked up on warrant because of contact with Miss Mata. So that's the nature of the offense. You will be, so that is the nature of the bench warrant that was put against you. You have the right to a hearing on this PA 353 violation. You have the right to counsel. You have the right to have the people prove that you were not in contact and you were not in violation of this order. Your next date on this matter, my understanding is you'll receive a notice to appear within 48 hours of today's date in order to appear for the PA 53. Mr. Sartz, is he going to seek? I'm assuming he's seeking public defender counsel in regards to the pretrial on this matter to be set, and the PA 53 will probably be set at the same time.
Your Honor, he's already been approved, and he's represented by Aaron Schroeder from our office. Ms. Schroeder will handle those responsibilities. It's my understanding that the pretrial was originally scheduled for March 6th, but
all right.
Certainly, if at this point, he needs to, appear sooner, then that's fine as well. Thank you.
All right. So it's a March 6th date, PA 53 violation. I'll update. Do you have any change of address, Mr. King, in regards to the Walton Drive or the phone number that was originally given to Judge Buchanan at arraignment?
No.
All right, thank you. So I have 3801 Walton Drive, apartment 10, Lansing, Michigan, 517-944-9468 as the information provided. The court will enter a not guilty plea for purposes of this arraignment. Mr. Sartz, would you like to be heard on bond on the PA 53?
Thank you, Your Honor. Respectfully, and I understand it's a long shot given how Judge Ward typically views these types of allegations, but I would request that the court consider an interim PR bond as it relates to the alleged PA 53s. Mr. Walton, or excuse me, Mr. King, my apologies. From what I understand, certainly understands the significance of allegation along these lines. He will make every effort to comply with the order. Certainly, he understands the magnitude and importance of following with the orders, and whatever the underlying issues were, he'll make sure that he avoids those concerns in the future. From what I understand, he does have several children in the area, and he does have plenty of connections in the community. He is not going to be a flight risk at all. And at this point, respectfully, I would request the court consider an interim bond until has the opportunity to have a hearing on the issue. Thank you, Your Honor.
Thank you. This is a Judge Ward case. I understand her indication that a no contact bond is a pretty big deal in a domestic assault cases. She's indicated that. I don't know that I'm good remanding it, although there was a $500 PR bond set initially. So I'm gonna take a look at the underlying offense. I will give a bond in this case, but I'll take a look at the underlying offense, which is $500, and I will now make it a $500 cash or surety.
Thank you, Your Honor.
Thank you, Mr. Sartz. So, sir, your bond is set at $500 cash or surety, and you will receive within 48 hours of your arraignment a time to appear in front of Judge Ward concerning this matter. All right, sir?
All right. What does the $500 cash or surety mean?
Means $500 cash or whatever your plan you can put up for that amount for a bondsman to make surety as to that $500. Is that the safest way to say it, Mr. Sards?
Correct. $500, sir, would mean that you can either pay $500 directly to the court and bond out, or you could hire a bondsman, and they usually charge, around 10% of the value. But in a situation like this, they'd probably charge you around a couple $100. But either way, you have that choice. If you hire a bondsman, it's non-refundable. If you pay the money to the court, assuming as long as you comply with the court's bond conditions, if there's any money left over at the end of the case, you'd get a refund of those funds. So that would be up to you, sir.
Correct.
If you're unable to post the full amount to the court directly, you'd have the option to potentially hire a bondsman who could put up a cash or surety agreement in exchange for a payment. Okay.
Okay, I don't have nothing, so it's okay.
And that's a choice that you have too, sir. You don't have to post your bond if you would prefer not to.
Well,
Right.
I would want to, but I don't have no job, no money, no family, no, it's
All right. And thank you, Mr. King. And the same bond conditions are set that were previously set by Judge Buchanan.
Okay.
All right. So that's all for the record on the PA 53 violation concerning 2202-841. And then we'll have Mr. Earl Lee Flynn. So you're all set, sir.
Sir. Reach it. Step up there, son. Go ahead and step up there, son. Onto the table.
All right. Right here, sir. And sir, you are Earl Lee Flynn. Oh, I can't hear you, Mr. Oh, there you go.
Fly. Earl Fly. Earl Fly.
Okay, Earl Fly. Thank you. Earl Lee Fly. Mr. Fly, this is the time set for an arraignment on a failed to appear on an open alcohol. There's an indication that you failed to appear previously. You were show caused and failed to appear. And you have an outstanding balance of $120. That's why you had a bench warrant out for you, sir, okay?
Man.
Do you understand that?
No, I understand that now.
I'm sorry, I didn't understand what you said.
I ain't understand that. I got one of me. Well, I ain't know that.
You failed to appear to show cause on September 24th, 2019, and then you failed to appear on December 11th of 2019.
I don't remember that.
And so you have an outstanding balance of $120. That's what, for that failed to appear, you were picked up on a bench warrant, and now you've got $120 outstanding balance. Can you pay that $120 today?
I ain't got no job yet. And I ain't got no income.
No income.
Your Honor, respectfully, if I may just interject, Mr. Fly is homeless. He lives on the streets. This is a really, relatively speaking, an older warrant. Respectfully, would Your Honor consider just administratively closing this? I suspect he'd have a lot of financial difficulties trying to come up with the money.
Right. Well, it's interesting you say that, Mr. Sarks, because that's going to be the plan here. I think the plan here is, Mr. Fly, I'm going to administratively close this file.
Okay.
All right.
Okay.
The $120, and I'll dismiss the bench warrant.
Okay.
And sir, so the bench warrant's dismissed. The balance is administratively closed at this time. So you're all set, Mr. Fly. Good luck to you, okay?
Okay, thanks, Judge.
Thank you, Your
All
Honor.
right.
All right.
Thank you, Mr. Sarts. I think, I'm not gonna say it because they always get mad at me that was a pretty decent day, but who knows what tomorrow will bring, right?
Yeah, I'm knocking on wood, Judge. That's about as smooth as it goes for weekend arraignment.
It is. And if I only had that power, if I only had the power, that power, I'd make every day like that. But thank you for your appearance today, and we'll see you tomorrow. Are you with us tomorrow morning?
Yes, Your Honor. Thank you.
All right, we'll see you tomorrow morning. Enjoy your Saturday. I think we're all set in the jail. Thank you.
All right, thank you. Have a good day.
You too.
All right, make sure you log out from YouTube because you left it out. When I got in this morning, it was